Good evening and welcome to Know Your Rights. I am your host, Khadija Usher. On our show, you hear directly from attorneys who break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. Tonight, our topic is wills and after-death benefits. You can watch us live on Channel 7 or on Facebook at Colorblind Multimedia Productions. You can also participate in the conversation by posting your comments or questions on our Facebook page. Joining us tonight to discuss this topic is attorney Stevanni Duncan. Good evening and welcome, Stevanni.
Hi, good evening, Khadija. Thank you for having me.
Thank you for being here. We're discussing wills. It's definitely not a topic that you want to talk about because of the time in your life when you would probably be doing it or should be doing it. Can you give us an understanding of what is a will, first of all?
You're very right. A lot of people are reluctant to embark on the preparation of a will, but a will is something that is very important. It is a written document that expresses the intentions of what we call in the legal world a testator or a testatrix. That is the person who makes the will.
The person who writes it.
Correct.
Okay.
And the person essentially puts in the will what he or she wants to do with his property after he or she passes away.
And when you say what he or she wants to do with his property, firstly, I want to get into the physical document. What you could put in there, anything you could put into your will, what you could sign over.
All right, essentially you put any property that you own. You can put in the real property or personal property. That's what it is under the law. But essentially, if you have land, if you have furniture, jewelry, you have shares in a company, you own a boat, all of those things you can put into your will, and the will is supposed to be kind of an instruction as to what you want to happen to that property.
Okay.
So the will contain different provisions that they call bequests or devises that say, I want to give my boat to Khadija, I want to leave my car to Jane. So that is the information that you put into the will. But let me tell you about the form itself.
Yes.
There is actually no specific form that you go and pick up and you fill out the blanks and that is the will. No.
There's no like format you could say you could go to the court and maybe pick up or like a drafting template or so you could use or have to use that would be like, this is a will?
No, not necessarily.
Okay.
Really and truly what makes that written document a will are certain requirements that are provided for under the law. For example, the will must be in writing.
Must be in writing.
Correct.
Yes.
Also, the will must be signed at the end of it by the testator, the person who's preparing the will.
Yes, yeah.
And it must also be subscribed by 2 or more witnesses. Normally, two suffice. 2 is okay.
2 is okay.
Correct. But the important aspect about that is the witnesses who subscribe the will or who witness the testator signing the will must do so in his presence, his or her presence.
Yes.
And they must also know that that signature is the signature of the person making the will.
Okay.
In other words, if you're going to prepare a will and you have your witnesses, the witnesses must be present to see you sign your will, or they must be present together at the same time to see you say, here is my signature, I just wrote it. Okay, that's very important for the witnesses to be present at the same time when that happens. Then the witnesses sign that document.
Okay.
Another important feature is that those 2 witnesses cannot be beneficiaries under the will.
They can't be receiving something in the will.
Exactly.
Okay.
So a beneficiary is a recipient of one of the gifts under the will. And if I'm going to give you my car, then you can't be the witness to my will because you're
conflict of interest.
Exactly.
Yeah.
So it is always advisable to get third party witnesses,
Okay.
no one who is going to benefit from any
From
gift
the will.
under your will, correct?
I noticed, talk about the lawyer. Does a lawyer have to be present? Because you talk about the person who is doing the will, you talk about the witnesses, but no word about a lawyer. Do you need a lawyer to facilitate a will?
You actually do not need an attorney to prepare a will.
Yeah.
Certainly, it is helpful to have the advice of an attorney. And actually, if you really want to avoid any mishaps, because it would be a very sad day if you go through the trouble of preparing your will, only to find out, well, you wouldn't find out, but your family would find out that the will is invalid and that they cannot give it the effect. So I would suggest that you go to an attorney to get at least advice so that when you prepare the will, you know you're preparing a valid document. Because if it's not proper, the courts can turn it away and say, this is not a valid will. What that will result in is you not having a will, and you will fall under intestacy, which is essentially the state that you fall in when there is no will.
Oh, there's no will.
Correct. So,
Yes.
sorry, I just wanted to go back to the testator.
Yes.
Can prepare the will on his own without an attorney, as long as those requirements that I mentioned earlier are part of the will, okay?
And we talk about the signing.
The signing.
As well as your witnesses.
Correct.
And it is advisable that your witnesses are not beneficiaries of the will.
Not just advisable, it cannot be that
okay.
they are beneficiaries
Your,
of it.
your witnesses cannot be beneficiaries
That's
of
right.
your will.
That's
Straight.
right.
Can you continue with the process after this will is drafted and it is signed by all parties? Is there a place that you go to register your will, file your will? Where you do with your will after that?
There is nowhere that you need to, as a matter of law, go and deposit your will after you've prepared it. There is some provision that, say, if you want, you may take it to the Supreme Court for the Supreme Court to keep it, and you pay a fee and that sort of thing. But as far as my research goes, that actually has not happened before.
Yeah.
So generally what we do, for example, as practitioners, is prepare the will for the testator, and we make 3 copies. And we would keep 1 copy and probably hold on to that until, the relevant time. And then we would give the testator 2 copies, and they're free to do with those copies what they wish. And it's advisable that they deposit at maybe one of the copies in maybe a safety deposit box, or just some place that it can be kept safe.
Okay.
Another option is they can perhaps give it to a trustworthy family member or a friend that can keep it safe for them.
Yes.
But it's important that you perhaps let at least one person know of the existence of your will, and that this is the place that I'm keeping it, so that when that time comes around, that person may know exactly where to go to find your will.
Have you encountered situations where it is believed, maybe by a family member of the person who has passed, that a will actually exists, but just nobody knows where it is then, or nobody is fessing up to have witnessed that this will is in existence?
Unfortunately, if you cannot actually find the document, then you'd be unable to prove the existence of this will, which is why it's important that you have multiple copies, and you probably keep them in different locations, so as to avoid a situation where nobody can locate the will.
Yes. And so, if going back to the persons involved, and I just want to reiterate everything that is necessary on the document, apart from the belongings which you're giving to beneficiaries, your signature, the witnesses, and that you do not need a lawyer. You said that anybody can really just draft their will. It's important, I think, because a lot of people always feel that these legal documents are very formal and must be a very certain way, and they must invest in money to see a lawyer. But in terms of what happens if you do not make a will, then what is the stress then from that end versus what you would go through to do it? Because I think a lot of people that think about going through the process?
That's a very good question. As I mentioned earlier, if you do not make a will, you fall into this circumstance that we refer to as intestacy, right? So it's called intestacy when you do not have a will. And when you are an intestate, the law governs what happens to your property. So you no longer have the say-so in terms of what you want to have happen to your property.
Yeah.
The law prescribes who what goes to. And if you want me, I can get into some of the finer details. For example, if you die and you have a spouse, a surviving spouse, and children, what the law says is that the surviving spouse is entitled to your personal chattels as well as the net sum of $600, right? From the residuary estate, and I know we didn't talk about the residuary estate, but the residuary estate would be essentially what's left over kind of thing after you've gifted specific properties. So from your residuary estate, the wife would get, or the husband, 1/2.
Okay,
correct?
So it's very specific. The law really takes it into its own hands.
If there are no children. If there are children, then the wife would get 1/3. And then the remaining 2/3 is shared up equally between the children.
Okay.
So that's just one example. You can have another example where you have a surviving spouse, no children, but you have parents.
Okay.
So in that case, the same thing applies for the wife, where they get the personal chattels. They also get the net sum of the $600, and then they get half the residuary estate. And then the other half is shared equally between the parents, if both parents are alive. If one parent is alive, then that parent takes the balance, the residuary estate for themselves.
Actually, Stevanni, I want to get more into this, as well as how, if or how this can be challenged, those things that you just said. But we just have to take a short break, and we will be right back. And welcome back to Know Your Rights. I am your host, Khadija Usher, and we are here with Stevanni Duncan discussing wills and after-death benefits. There's one set of persons who we actually did not mention, who are the executors. I'd like for you to explain their roles in the will.
All right. The executors are basically the keepers of the will, so to speak.
Okay.
So once a will is made and the person dies, the person who is named or appointed the executor in the will is the one who is responsible for probating the will, which simply means taking the will to the court, proving it as a valid will, and then getting the authority from the court to act on the will and to administer the will and to give out the assets according to the instructions of the testator, right? So for example, the executor goes to the court, and there are certain forms that they fill out, and what they get from the court once the will has been proven is called a grant of probate. You may be familiar with the term. Grant of probate. That document is a document that essentially authorizes the executor to go out there now and manage or handle the assets of the deceased person.
So these are very important people.
Very important.
Because you done dead.
Correct.
So these are the ones who really want to make sure your wishes and desires, as you stated earlier, are carried out, carried forward.
So you want someone that you trust, or some two people, because you can have more than one executor in your will. And there are a lot of testators who prefer to have two, and they act jointly, which serves as a check and balance, so that the wishes of the testator actually are carried out. Another option is that the executor, you can name two executors, but actually they're named in the alternative. So I name you, Khadija Usher, to be my executor. But if you, for whatever reason, can't do it, I then name Jane Doe to be my backup executor, so to speak.
I see. And when you say name, you mean that is written in the will itself?
Yes.
This is my executor?
Yes.
So this is a segment that you need to include in the document?
Yes, there is actually a paragraph in the will that will say, I appoint Jane Doe of such and such address and so forth, and you name that person as your executor.
And suppose something, maybe you touched on it already a little bit by naming more than one people, but I'm thinking suppose something happened to these people, or they cannot carry out their duties, or for some reason they don't want to. And I mean, you're gone, as I said, these are important people. What happens in that instance?
Well, hopefully that before you name the person or persons as executor, you've kind of done a consult with them to say, hey, I'm going to name you as the executor in my will. Are you up for the task?
Okay.
And they agree. And so at the point when you pass away and it's time for them to perform their duties, they do so willingly. You could have the unfortunate circumstance where perhaps your executor or executors pass away, or for whatever reason simply decide they don't want to perform the duties of executor. Then they can renounce their executorship or simply not move to prove the will in the courts.
Yes.
What happens in a situation like that? Someone else can take up that task, and it could be one of the beneficiaries named in the will. They wouldn't be considered an executor because the term executor is specific to that person who is named in the will by the testator. Okay.
And I want to move into the areas that could possibly conflict or challenge the will itself. And I want to speak on part of the testator first, the person doing the will. How does the marital status of the testator actually affect the will? Because I'm a single person, and if I'm writing my will now, I'm probably assigning certain things that I have, but then I go get married. I have other things, or maybe things become me, for me, whether for me, that for you, or whether for you, that for me. You know, life has changes like that and events like that. So how does the marital status, first of all, affect the will?
I like that question, and it's very, very practical and very relevant. If you make a will when you're single, then you certainly may want to change it, you know, when you've gotten married to someone, and perhaps your gifting would be different after you've married to someone. And so it may call for a revocation of that original will, or sometimes you can amend the will. But what I think would be the safest bet would be to revoke that original will by preparing a new document, a new will, right? And so in the new will, you have a paragraph that revokes any previous will you may have drafted, and then that current will, and of course you need to date your will, that current will then be the valid document. Now, a scenario where, for example, you are married, right? You're married and then you, say for example, get divorced, and you enter into another relationship with someone else. If you have prepared a will contemplating your spouse, this might be a good scenario for you to revoke that will so that you can probably make provision for your new partner.
And when you say contemplating your spouse, you mean in the terms of the will, what make consideration for the marriage?
For the spouse, correct? Because there may be a scenario where some of the gifts or some of the provisions under the will, maybe they lapse. So divorce does not invalidate the will. But it could be that some of the provisions are no longer relevant because that particular person is no longer your spouse.
Okay, so like you left something and say, I want to give this to my husband or my wife. But technically, you don't have a husband, got a wife no more. That means the whole will throw through the window.
No.
It just means that certain sections are not applied anymore.
Correct. And so in a scenario like that, it is advisable that you prepare a new will that that is more relevant to your circumstances.
Yeah.
Correct. Now, if you prepare a will, then you get married. I think I'm not sure if I mentioned it, but your marriage actually automatically revokes your previous will.
Really?
Yes.
Okay. So you, that one is kind of an eye opener for me. So you can have this document, but just the institution of marriage revokes the will.
That's correct.
Okay.
Unless you may have known you were getting married, so you decide to put a paragraph in there that says, in light of my upcoming marriage,
Okay.
But other than that, if you've
Yes.
prepared a will and then you get married,
Yeah.
that marriage automatically revokes that
Yes.
previous will.
Okay.
Yes. So you have to bear that in mind.
Yeah. You see, this is why I like this show, because the lead tips like that, those lead tricks, we have to apply them. I know I'll apply them. So right now we'll take a very short break, and when we return, Stevanni will be answering some of your questions. We'll be right back. Good evening and welcome back to Know Your Rights. I am your host, Khadija Usher, and we are here with attorney Stevanni Duncan discussing wills and after-death benefits. So at this time, we thank you for your questions and comments on Facebook. We have selected 3 of your questions to ask our guest attorney. Firstly, Marina wants to know, do we still have to register wills at the titles unit? Does it have to be drawn up by an attorney? Does it have a special format?
Okay, I think I pretty much responded to all of these questions in our earlier discussion. No, you do not have to register your will at any particular location. It's simply important that you keep it somewhere safe and probably inform someone trustworthy where that will is being kept. If you use an attorney, then it's very likely that the attorney would also hold on to a copy of that will.
Okay.
No, it does not have to be drawn up by an attorney, but remember that there are certain formalities that must be complied with in order to make the will valid. So if you want to ensure that your will is a valid will, perhaps it's best that you go to an attorney to either have them draw up the will or simply get consultation and review it. Yes. If the what was the last question? The format?
Final one was if there's a format or like a template as we discussed before.
Again, there is no specific format, but there are specific formalities that must be complied with, and these include the fact that it's written, the location of the signature, which must be at the end of the document.
Okay.
You can't have the signature and then something after it, because that portion after it would not be
considered signed.
a good, correct.
Yeah.
And then the witnesses signing as well, and of course the witnesses cannot be beneficiaries under the will.
Yes. Okay. I like when the viewers end up asking the same things that we discussed, because I feel like then we're up on the same page a lot.
Yes.
Yeah. Our second question is, if a mother of several children dies, leaving no will, can one self-appointed power of attorney legally exclude all other family members the right to their mom's property?
I'm not sure what is meant by all other family members. I'm kind of guessing here that they may mean exclude family members not being the children. So assuming that that is the case, the mother not leaving a will, the law provides what happens to her assets, to her properties. And this is a case of intestacy. I mentioned that earlier.
That word, yes.
So where she has no spouse and only children, what happens is that the children will inherit all her property, absolutely, and they will share it equally among themselves. Okay?
Yeah. And our third question, Ken asked, if someone dies without a will and his estate is still in his parents' name, he had a common law wife of 20 years and 4 kids with a different woman, how can they divide the estate?
All right. He died, he doesn't have a will.
No will.
All right.
Estate in parents' name, he had a common law wife of 20 years, 4 kids, but different woman.
Okay, Ken, this is one where you need to go to an attorney, But I will tell you that essentially what I understand from the question is you have now inherited your parents' property. Let's say, for example, it's a piece of land. It was in your mom's name. Mom died, and so you are the proper beneficiary of that property, assuming so. Then you have your common law and your children from a different woman. Okay, this is another case of intestacy because there's no will, which means that the law governs what happens. So where now you have a common law spouse, so that person is treated as if the surviving spouse under the law, right? And that person will get, under the law, $600 from your net estate, as well as the personal chattels that I mentioned earlier, which include just little property, movable properties, correct, if you have furniture, what's not, and the 1/3 of the residuary estate. Your children now, whether they be from the same woman or another woman, will get 2/3 of the residuary estate shared equally among them.
And you may mention the residuary estate or basically whatever left behind.
Correct. Since there's no will, there was actually no specific gifting of anything. So it's almost as if your whole estate is a correct.
I got you. And we want to touch on one final area, and it's a conflicting area that we have been approached with in terms of you have a will, but there are other assets or at times finances in your life which are with different agencies. For instance, my pension with my work. The first thing they have, the side of your pension, when you fill out your line, the beneficiary, this person. There are instances when sometimes you start work and you that are the same spot for 20 years, you don't go back, go change that. If you're like me, everything signed over to your ma right now. Kind of got nobody else, right? But 50 years from now, you know, I write my will and I sign it over to somebody else, maybe a husband. Who then? Which one trump which one? Who we go to?
Oh, well, that document that you signed with your company, with your employer, is what will trump your will. And it's actually a very commonplace scenario. So if it is that you want to change who is your named beneficiary for your pension, for example. If you want to change that, then you should go back to your employer and make sure you change it on that document. Essentially, it's as if you've entered into a contract with your employer kind of thing. So your employer is not going to pay that out to anyone else except your named beneficiary.
I see.
Yes. So even if you have a will naming someone else, that particular gift will lapse. It will fail.
Yes. And it's actually very interesting because it happened to a lot of people.
It does.
I've heard it happen.
It's very commonplace.
And in the same terms of challenging the will, and this is our final question before the wrap up, if any dependent of somebody who has passed and the person had a will, but this dependent felt that he or she was cheated by the person leaving the will, let's say maybe a child who is from another relationship, where would I say outside children or so, come and say, well, you know what, I'm his picnic too. I deserve a share, and he never put me in at a will. Can that be challenged in the court?
Well, let's put it this way, that if you feel you are aggrieved and maybe there is something challengeable about the will, yes, you can go to the courts and challenge it. And without getting too technical, there perhaps can be circumstances where someone who feels that they are a dependent and should have properly been a beneficiary under the will, or they should have been given a little bit more than what they were given. Say, you know, you have your brother and your brother get the whole 2 farms that dad owned, and you happen to just get, I don't know, 1 pig. Maybe you feel completely like disinherited and you think that is an injustice, so perhaps you may want to challenge it from that perspective. So yes, you can go and challenge it, but the circumstances will dictate whether or not you have a successful challenge.
And what is the final wrap up, or what you want to emphasize about the wills? We discuss a lot. That was a heavy topic.
It is.
Every week, I whenever I get a new topic, I say it's a heavy topic. I feel like this one, I mean, one of the heavier ones too.
Yes, it's very relevant. I would suggest that no matter how big or small your estate might be, how much property you think you have, and sometimes we have future property coming in, you know?
Okay.
So even that falls on your estate. If, for example, a debt is owed to you and you die before that debt is paid, that debt falls under your estate, right? That money owed to you. So no matter how much property you have, I would advise that you prepare a will. It saves your family, it saves your loved ones from the hassle of trying to figure it out. And too often you see families fall apart because of the confusion that arises because this one want that property, that one want that property, no, this is for me, that for me. So to avoid it, the safest route is for you to sit down right now and prepare a will. And guess what? As soon as you're 18, you can sit down and write, I give my bottle of perfume to my sister. And every now and again, you can go back to your will and you can update it depending on what stage in life you're at. So those are my final words.
Thank you. And we have come to the end of our show for tonight. Thank you, Stevanni, for joining us and providing important information on tonight's topic. Next week, the president of the Bar Association, Priscilla Banner, will explain your rights when engaging an attorney at law. Tonight's episode of Know Your Rights repeats at 1 p.m. on Sunday on Channel 7, and it will also be available for viewing on Facebook and YouTube. Thank you for watching and good night.